this afternoon. Today we have a workshop on a very important topic. The title is Importance of Non-Disclosure Agreements and Restrictive Covenants in Employee Agreements for Startups and MSMEs. This topic does not get the attention that it should warrant. See, when a startup is formed, normally the energy is very high and the focus is on getting work done. But as startup scales up and it starts getting into business discussions, it starts adding team strength, grows in size, various issues come up. And what happens is that if certain things are not taken care of at the outset, they can really have a long-term effect on the performance. So the goal for today's discussion is to throw some light on this topic and what startups and corporations of actually all sizes, but particularly what startups should take care of. I am Himang Shah. I am a professor of Tech Council in Africa. I also lead the Qualcomm Design in India Challenge, which is a startup program that has incubated now including 89 startups across the few years. Today we have two eminent speakers. First, we have Mr. Ravi Bhola. He's a partner at KNS Partners and he chairs the patents practice of the firm. Ravi has handled filing, prosecution of several thousands of patent applications for clients. He covers a variety of diverse areas such as biotech, bioinformatics, software, nanotech, pharma, electronics, communications, and mechanical. He also has a vast experience in the handling of design applications and the related issues. I'm aware of his work in wherein he has represented several MNCs and domestic corporations on issues. Passionately, I must say, he regularly conducts patent workshops and invention capturing sessions for clients. Thank you, Ravi, for joining us today. Our second speaker is a dear colleague, Anirban Mukherjee. He's a senior manager of government affairs at Qualcomm. Anirban leads the Qualcomm wireless reach programs in India and Southeast Asia, and he manages a diverse portfolio of social sector programs in health, education, and environment domains. And Anirban is a true blue, passionate member that has developed the Health Pro e-learning program. And these days, he's on hitting the next milestone of 5,000 learners. So please help us reach that goal. We are at 4,100 something. So just a bit further away, and with your help, we can be there. So without further ado, let us dive into the topics today. And I'll invite Ravi to first share his thoughts. Ravi, over.
Thank you so much, Hemang. A big thank you to you, to Qualcomm, to Anirban, and of course to Yashpal and other folks at SHM for having me for this interesting event. What I'll do is I'll share my slide deck and then we go straight into the topic. Just you guys can see my slide deck.
I can share, Ravi, just one note before we get started.
Sure.
Let's keep this interactive, please. So
Absolutely.
the chat box. So for any
Absolutely.
please type it in the chat box, and when the time is right, I can either interrupt our speakers and let them know, or we can ask Ravi to cover at the appropriate time. So please keep your questions active in the chat box. Thank you.
Excellent. Thank you so much, Hemang. And Hemang, I might not be able to actively see the chat section, so do let me know when I need to pause and take up some of those questions. Yeah, thank you. So very good afternoon to everyone. Delighted to be part of this session. What I'll try to do is to keep this topic pretty wide and open because you might be a startup, you might be part of a large size corporate, you might be part of a government institution that works with private players. So I've kept it very broad, looking at, of course, employee agreement in mind, but in certain instances, I'll go even beyond that in terms of subcontracting or using gig economy to leverage your businesses. So when we talk about NDA or non-disclosure agreement, we're essentially talking about a kind of a legal instrument to create certain obligations, right? So here is one party, for example, which is disclosing certain information which that party believes is confidential. On the other side, you can have the party, which could be, for example, an employee, or it could be a subcontractor who is receiving that, let's say, confidential information. So there's a transmission of information happening, which is construed as confidential. So therefore, it's imperative that you have some sort of an arrangement in place, which can ensure that as a disclosing party, your information is kept confidential, is used only for the specific purpose for which it is shared. And then once that purpose is served, you have some mechanism to make sure that the information still stays, let's say, confidential, even after the term of that, let's say, employment contract or a subcontracting agreement is over. Or there could be other kind of situations where the receiving party in some cases is free to disclose that information at a later point in time. And I'll talk about those scenarios. It's always advisable to have that NDA done before you start disclosing information that you believe is confidential. It could be, for example, with respect to an employee, it could be about the project the employee has to run. It could be about the client list that you may have. It could be about price sensitive information that you might have. So make sure it's ideal to have that NDA in place. But sometimes, you can have a non-disclosure clause sitting in your employment contract itself, which can make it obligatory on the employee, for example, to keep that information confidential. Now, when you're designing an NDA, let's say, it's important also to make sure that, you know, if something goes wrong, how do you deal with those situations? So I'll talk about that in a while, but I think your framework, even as a young company, and while you're doing a lot of things like Hemang mentioned, make sure that your NDA or agreement does provide for provision in terms of any breach of the contract, any leakage of confidential information. How do you deal with that? Which could be in terms of whether it's you get into some sort of a adjudication mechanism, which court you can approach, what kind of compensation or damages you can seek. So all that becomes part of the whole thing. Now, these are the very typical examples that we all know of information which is confidential. In some cases, it could be even trade secret. In India, interestingly, the trade secret and confidential information is used interchangeably because we don't have a law specifically for trade secrets. But in the more developed economies, trade secrets, of course, it can fall within the bucket of confidential information, but a separate legislation is provided to protect trade secrets, because you can say trade secrets are kind of information which provides competitive advantage, and disclosure or leakage of that trade secret can lead to significant financial losses for the organization. So that's how it works. But then it could be anything. You can have a chemical formula, you can have some sort of a protocol, a software protocol, customer list, all of that. So it's important that you have a mechanism in place. Now, I briefly touched upon earlier about certain exceptions which may not necessarily fall into your NDA in terms of confidentiality. So think of it. You may believe you're sharing something with an employee which has already appeared in the newspaper yesterday. Now, is the employee obligated to keep that information confidential? No. So typically these three, four are the typical instances where you'll see even an NDA would have certain exceptions. Um, for example, if I'm an employee and I'm directed by a court to disclose certain information to the court as a part of some proceeding. Now you as an employer might think that, hey, Ravi is my employee, he has signed an NDA. How can he disclose that information to the court? Now, if I have a compliance requirement with directions from the court, then the NDA cannot prohibit me from fulfilling my obligation to the court of law. Similarly, there could be situations like, let's say, in a very competing new technology, let's say in EV industry. There's a lot of innovation around batteries. Two independent groups have independently developed the same invention or very, very similar invention. Now you can't say, hey, you have developed something, after getting that information from my end, because other group can always allege that, look, I had independently project going on and which led to this innovation. So there could be some interesting situations which provide for standard established exceptions through the confidentiality agreement. And these are, I would say, largely global in nature. It's not limiting to India in that sense. Now, while legal instruments are always available, like NDA, confidentiality agreements, and things like that, uh, I think with time we all have realized that it is also about building a culture to respect innovation, and culture to then make sure that you have a mechanism in place to keep that innovation confidential or any other information confidential. Now, you can have some very interesting situations. And sometimes, I've seen that startups are particularly worried that this smart employee having access to a lot of information will tomorrow go to a competing player. But if we step back a bit and look at when that employee had joined us, did that employee actually bring in any confidential information that I shouldn't have access to? These are also very interesting conversations that you need to have to see that not only your confidential information is not, shared with somebody else as third party. At the same time, you should also not be a recipient of somebody else's confidential information. So what checks and balances you have when you are inducting someone in your team? What checks and balances you have when you are partnering with a third party to provide you certain services, so that you don't end up infringing somebody else's uh, innovation or don't end up accessing confidential information of another party. Another thing which I have also seen is that when we do the exit interviews in young companies, there's a lot happening. There's a lot happening all the time, and entrepreneurs are busy in multitasking. But it's very important that you have to have a kind of a good, robust mechanism in place when you're also getting into an exit conversation with an employee. How do you map uh, all the key projects that person had undertaken during the employment with you, how they are docketed as confidential information or intellectual property, and then how do you ensure that that person is sensitized even at the time of exit to see to it that the person is acting responsibly as that person goes out. That person may go out and join your competitor, and you can't really do much about that. But being in the culture, education, I think is a very important part of protecting your confidential information. So it's not only managerial control, it's not only technology control, but a lot of other softer ways to bring in a culture to keep the information confidential. We have seen instances where you see insider trading happening, where a listed company is about to make their quarterly disclosure, and some folks, even in the senior management, having price sensitive information, and they leverage that information to make some personal gains. So it's important that you not only look at having NDAs and those kind of tools with your employees, but within leadership team, within management team also, you need to have a good, robust system in place. And I think any organization, any management which is mature will understand the value of doing something like that. And when you talk about, information for startups, client list is important. different or innovative ways of servicing client could be very important business sensitive information. So that kind of educational initiative is so very, very important as a part of, uh, you know, uh, running an organization. Now, often when we, get into some conflict situations or in the litigation matters around this, um, typically what we see is in the maddening rush, because there are deadlines, delivery deadlines, project deadlines, information gets shared first, and then uh, often the requirement for NDA never really occurs. It's very, very important that you have some sort of a checklist when you're partnering with third parties or having any kind of a new project where you may have a JV partner, you may have somebody from gig economy being leveraged um, for executing certain project. There's a lot of noise. Can we have everyone on mute, please?
We'll ask people to go on mute.
Yeah, thank you. Yeah. So I think it's very, very important to make sure that you have an NDA in place. And sometimes, it becomes a little sensitive conversation. With employees, honestly, it's much easier. It becomes difficult as a young company if you're looking at, making a pitch to an investor or a prospective investor. And how do you have that conversation, for example? And investors, most of the investors I have seen globally, honestly, not limiting to India, are not very comfortable, signing an NDA before receiving any information because their counter argument is, I might have had heard this idea before through another pitch. So why should I get into an NDA or that kind of a thing? There are other softer ways to deal with it in terms of making sure that information you share with them is, through any e-communication, everywhere as a footer or a heading, you talk about that information is confidential, and, da 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 da, it's, sole proprietary of my company and stuff like that. So you find ways to still establish that what you're sharing is a confidential information, and thereby the other party indirectly has an obligation to treat that information as confidential. And then the onus shifts on the other party to establish that the information they received was not confidential. But at least from your end, in those few delicate situations, you can look at this as a possibility. But just make sure that in all possible scenarios have that kind of a agreement in place. Sometimes, even a very casual conversation can lead to transmission of confidential information. So it's always a part of the best practices that you should have that in place. Do we have any questions at this stage, Hemang?
There is one question from, I'm sorry, I will not be able to pronounce your name properly, from Mukchada. So the question is that, do you still need a separate NDA, although an employment agreement may be in place? So do you need both? Do you need just one?
Yeah. So typically what I have seen is most of the employment agreements do have a generic clause on confidentiality. Um, what I find missing is that because the focus of that employment contract is more around employment and not so much on confidentiality and how to manage and how to deal with repercussions in case there's a breach. Our advice generally is it's always good to supplement your regular employment contract, even if that has a clause around confidentiality, with a very specific non-disclosure agreement, which can be slightly more elaborate and more precise, which also provides for mechanisms to deal with situations. So that's what our general advice is. It's not legally mandatory to do it, but it's just that the focus is more when you have a supplementary NDA in place.
Thank you.
Yeah.
And there's one more question related to NDA from Vinny Jose. Can NDA be signed with minors, like, under the age of 18, folks, or is there an age limit to it?
Yeah, our advice again here is that if you have someone who is an underage in that sense, less than 18, it's always advisable to have that execution um, countersigned by a guardian, so to say, just to enhance the legal validity of that confidentiality agreement or an NDA is what I would suggest. It doesn't mean that if anyone has signed an NDA which is who's less than 18 won't work. Uh, just won't work. But I think it's always recommended to have it countersigned by a guardian, one of the parents or things like that. Yeah. Okay. So
I have
Hemang,
a few more questions, but we can take them later. Uh,
okay.
don't want to interrupt your flow too much.
Sure, no worries. Thank you. So now, if you look at typically what all is sitting in your NDA, and I think it syncs well with one of the questions that you had around whether we need to have a separate NDA or not, because some of these things that are captured here may not necessarily get adequately captured in a conventional employment contract. So of course, you talk about who are the parties, you're an employer, other party is an employee, or whatever kind of arrangement that you may have as a JV based agreement or not. Uh, Term. Now, term, it's an important thing, and I briefly touched upon that earlier, is that your contract of employment, for example, will come to an end, let's say once the person moves on or you ask that person to move on. So there's a term attached to for how long that person was employed with you. But then the confidentiality aspect of that employment contract can outlive the contract itself. And it's important to have that captured in your NDA or agreement to so that just to make it more explicit and clear that this confidentiality obligation on the receiving party or an employee, let's say in this case, will outlive the term of the employment. Now, you can have sometimes pushback on that, okay, that after culmination of the employment or culmination of a project, you can't have this obligation for perpetuity. And that's where, that those 3 or 4 standard exceptions that I talked about a while back are the counter argument that you can use. But ultimately, sometimes in negotiations, you may arrive at a term to say, okay, till 5 years after the culmination of the contract, for example. So some of it is kind of negotiable, but if you are the disclosing party of an information which is confidential, you may want to keep it for as long as you can. Um, uh, then, of course, you talk about ownership, which I think is inherent. Liabilities. What if there's a breach? Um, what kind of liability are we talking about? Do you want to quantify the liability, or you intentionally don't quantify because everything will depend upon the nature of breach and the kind of damage it may have caused to you as a disclosing party. But you have to have a provision around, you know, what are the liabilities for the receiving party in case of a breach. Jurisdiction. In today's world, in kind of, if I can say, post-COVID world where employee could be sitting anywhere outside India, for example, which jurisdiction will kick in if there's a case of a breach. So if you're an employer, obviously, you will have a upper hand, but then if it's a agreement between two, if I can say, equivalent parties in terms of stature or position or two corporates, then of course, this is something again negotiable. But it's always good to see that you have a jurisdiction which is more convenient to you. But it's important to capture jurisdiction rather than keeping it open. Another important, and I feel sometimes, rather, I would say a lot of times, is not taken into consideration is the destruction or return of confidential information once the contract comes to an end or term of arrangement comes to an end and things like that. Typically, we see, okay, NDA is signed, work is executed, invoice is raised, payment is made, and then you're done with it. Um, but what happens to the information which is sitting with the recipient after the project is concluding? concluded. So do you have a mechanism to say, okay, you will return every bit of confidential information that you had received as a part of the contract, or you will destroy all the material and information you have about that project, and confirm it to me, or or send out a certificate to me, saying that you have destroyed all the information that you had from our end, or which was seen as a confidential information per the NDA, for example. So all these are some of the important integral parts of a typical NDA or a confidentiality agreement. I briefly saw, I think there was some question around the jurisdiction and some example. So typically what we have seen, so there are different things. Um, Historically, places like for IP particularly, I have seen if there are two global players involved, and they're, let's say, of equal size. One might be sitting in US, another one might be sitting, let's say in Japan. I have seen agreements, and we've also drafted some agreements where parties say we want a neutral jurisdiction, where the where we will engage the court in case of any conflict. For example, I've seen, sometime I've seen Munich courts seen as a neutral party, a neutral jurisdiction in case of a conflict situation. Sometimes parties would say, okay, we will mutually agree for a neutral jurisdiction in case of a conflict. So it has to be, if at all there's a conflict, parties will discuss and decide which jurisdiction to go for. Some people in the Asia Pacific region, sometimes, for example, as a neutral jurisdiction, will pick up Singapore, saying there's a greater predictability in terms of systems and arbitration proceedings, which are quicker, cheaper, are pretty mature in Singapore. So you can have kind of situations like this. But if you're an employer, there's an employee situation. Employer will generally pick up either a regional headquarter or a main headquarter for as a jurisdiction. If I'm sitting in Bangalore today, and if this is if the center of gravity for my business is Bangalore, I'll prefer to put Bangalore because it's more convenient for me. So that's how generally it plays out. Um, just give me a second. I'm not sure why my slides are not moving.
Sir, you mean that the jurisdiction is for dispute resolution,
That's right.
or is
That's
the
right.
area of operation of the two partners, the Japanese
No,
partner and the American
yeah.
partner?
So what I meant was that the jurisdiction
Because
in case of a
dispute
conflict.
resolution is a separate clause. It is not a part of the NDA. It may come in the scheme of arrangement. What I personally feel is that NDA is a non-disclosure agreement, full form, so that the
Yeah,
things are kept secret and before the
correct.
scheme of arrangement is done. The
Yeah.
dispute resolution clause is a part of the scheme of arrangement. It is not a part of the NDA.
So it depends, it depends. You may want to have a separate provision or legal instrument around that. Uh, But at the same time, our own understanding and the practice, what we have seen and done is that it's always good to provide for the jurisdiction in the NDAs, because NDA, initial part of NDA, of course, the intent of the NDA is to make sure that the information is kept confidential. But what is equally important is to provide for a broad mechanism to deal with the conflict situation if there's a breach of confidentiality. So,
Yes.
I mean, I think there is no specific law which says that you have to have it together or separate. Generally, what we prefer or recommend is to keep it as a part of your NDA, so that it's not open to a different interpretation. And I'm not here saying that what you said is incorrect. It is just that what is comfortable for both parties. Uh, that's how it works.
So how
Okay.
do you differentiate between an NDA and a scheme of arrangement? like the two parties you are referring to, Japanese party and American party, they want to do some business and
Yeah.
they say that, okay, Mitsubishi says that I'll bring some auto technology to India, and there is some company like Musk brings in the technology for electric vehicles, and then they both set up a factory in Chennai.
Yeah.
And before that, setting up the factory, they do an NDA that we will start with this due diligence and everything. And then before that, there is an NDA. Once
Yeah.
the NDA is complete and all due diligence and is complete, valuations are done, and then a scheme of arrangement of the joint venture partners is done.
Yeah. Yeah.
So how do we take all these things into consideration
Yeah.
when we are we not mixing the two things, the NDA and the scheme of arrangement?
No, so what happens is that you look at the scenario where an NDA was signed, information was exchanged as a part of that NDA between, let's say, Mitsubishi and Maersk, as you said. And then during the course of that discussion to ultimately develop a business model and scheme of arrangements and things like that, in between there's a case of data theft. What if an employee of Mitsubishi takes that information at that stage, at the initial stage of exchange of information, and goes somewhere else and leaks that information? How do you deal with that situation? Now, till that stage, you haven't really got into a detailed business arrangement, and therefore you don't obviously have any clarity on jurisdiction and things like that. So that's where the ambiguity can come in. So in that context, it's advisable to have it. Now you can have an option that once you get into a more mature relationship is when you can reiterate that about jurisdiction. So there's no harm to reiterate, though it's sitting in the NDA. And NDA will not really become, let's say, irrelevant even after your relationship matures into a proper business association. So that's how you can look at it. Okay.
So why the
Now,
question of neutral jurisdiction comes into play?
so sometimes what happens, especially with the large businesses, I have seen that sometimes you don't want if you don't want to necessarily have the matter adjudicated in the courts of the other side, because you might feel that other party may have uh, either better understanding or may have a more psychological advantage, or in some interesting cases may have some influence on decision making. So if the idea is to be at par and be on the equal footing, and that's when some large size companies, which are, as I said, maybe relatively quite equal in standing, stature, and size, may go for a neutral jurisdiction.
I
And I
was
said
reading the annual
some,
report of SIAC, and they say that 99% of the cases which were educated at SIAC had the origin in India.
hmm,
So that
hmm.
means they are better equipped than the Indian arbitrators or Indian judiciary. Is it that mean
So
by neutrality? Or you
no,
see, most of the arbitrators in India are retired judges.
yeah.
That means
But
after their retirement, they lose their neutrality or all those senses, so that they go and educate those cases in SIAC, or the fees is more there.
So I'll take this question, and then maybe we can, take up the remaining questions at a later point in time, because I think it's already 3:34. But very quickly on this, see, it's just that in some jurisdictions, the adjudication, for example, by way of arbitration, might be more mature because they've been doing it in that country for a longer period of time. And it is not about just the credibility of one country vis-a-vis another country. It could be just in terms of more robust framework available, more robust legal framework available, or arbitration framework available, or a biggish or a
जी
more
सर
more mature, more mature panel of arbitrators available. In India, if you think of it in last 5, 7 years, Indian ecosystem has improved considerably, and our arbitration mechanism has really become pretty strong. We have, system in Delhi. We have pretty robust system in Mumbai and other places. So I think, that way, it's shaping up very well, even in India. Okay, so now, some of the maybe, I'm running out of time, so I'll be quick. Um, Here it talks about some of the situations
Mr.
where,
Ravi,
yeah,
you can continue. I mean, it's okay because I think people are quite interested in what you're
sure,
saying. So,
sure.
I mean, you can take the time.
Excellent.
Yeah,
Sounds good.
yeah.
All right. So then, here, for example, the disclosure that you make, um, let's say you have an NDA done with the other party. Now, you can have a provision to say that even within the team of the recipient organization, it's not that every employee in the recipient organization should have access to whatever information that I, let's say, as a disclosing party, has shared, right? Because the recipient organization could be an organization of, 5 lakh people. Tomorrow, if I share something with, let's say, with TCS, and if they have 5 lakh people or 4 lakh people, it doesn't mean that the information at the recipient side be available to all 4 lakh people. So you have to also see if you can bring in a provision in your NDAs to see that it is available only to the people on need to know basis. So that even at the recipient side, there is a kind of a control around who all can have access to that information, not everyone in that organization. And what happens, what kind of checks and balances the recipient party needs to have to make sure that the information is not transmitted beyond that. So all those can also be part of your agreement, also as part of educational elements. And what I have seen, and some of you might have also read about this and might already be implementing some of it, is about privacy issues and the data protection issues. While I'll not go too much into data protection issues at this stage, but a lot of that is intertwined. So one is the confidential information may include my client list, but then client list also then includes the personal information of my clients, which may have some individuals, and then the privacy issues also come in, which is again very relevant to the judgment we had from Supreme Court, which said that right to privacy is a fundamental right. So obligation is both on the disclosing party and also on the recipient party to see to it that such information is kind of has a maybe an additional layer of protection under the privacy laws. In India right now, the bill is sitting, and then it may become a law maybe later this year, and that's something then again which of course requires a separate session altogether, but you need to be mindful of that kind of information, which is a personal data protection related issue. Um, Now, but of course, the permitted use at the recipient end could be anything that the recipient needs to do to process that information that is received, which is confidential, and it's used for the specific task. So within that scope of work, anything and everything that the recipient party does is all legitimate. But then can you control, for example, number of copies which are being created? Um, and I think in this, so to say, post-COVID world, we have seen actually a significant increase in the instances of data theft because it's just that electronically it's if I can use the word, maybe sometimes more easy to transmit information or disseminate information. But even if it's a paper copy form or printouts, you know, can there be a regulation to say, hey, you can't just keep creating copies of my confidential information when you are executing my project. This is something that I touched upon a while back. And this is something, as I said, is often ignored or somehow missed by both sides is about making sure that there's a destruction of confidential information and and things like that. But then equally important is the issue that in certain situations, the recipient party might be required to keep that information or some part of it as a part of legal compliance or legal audit. Or there are certain kind of financial information, for example, which organizations are required to keep for up to maintain up to 7 years. So those kind of caveats or exclusions have to be provided, and some of it can be built into the agreement, or some of it it's inherently there by way of other laws. But this is something that we need to be mindful of when we are sharing confidential information around this. We talked about this in a way that if you have independent contractors, gig workers who are, let's say, working in a very specific domain, and every day they work with a different party, and all those parties are essentially competitors in the marketplace. Um, so how do you ensure that you are able to educate that gig worker and also have adequate kind of a contractual arrangement around it so that the gig worker acts responsibly while dealing with your confidential information? Very relevant because, as I said, if the guy is specialist in a particular domain and essentially servicing other players also in that very specific domain or subdomain, the risks are much higher. So you have to have that kind of a mechanism in place. But of course, certain information has to be disclosed, and it's to be disclosed in this manner. So this is essentially some of that is there. One important aspect I wanted to quickly touch upon is that you know um, sometimes companies can get a little too possessive about the fact that the person is moving on and has a lot of information in his or her head and will most likely join a competitor. So what happens to my information that is sitting in the head of that person? Um, so of course we talked about exit interview, recordation of projects that person had undertaken, what all that person had handled, broadly the kind of information that person had handled, how, per the employment contract, that information is exclusively owned by the current employer, repercussions in case of breach and all of that. So all that is all fair per the employment contract and everything. But at the same time, you can't really restrain a person from joining a competitor. That you cannot directly have an arrangement with the employee who's moving on. You've seen some corporates tend to have a informal arrangement to say, okay, I'll not take your person and you will not take mine. We've seen those kind of corporate arrangements. But then, the question also comes in that there's a right to livelihood for an individual, and therefore corporates can't necessarily restrict an employee from joining a competitor. Um, so therefore, education through the course of employment can really help such people act responsibly when they move to another organization. And again, what is important is that some people go for some corporates, go for a cooling off period kind of a model to say, okay, once you exit, there's a garden leave, 3 months, 6 months, we'll pay you X amount and you will not join the competitor for that period and things like that. So all those models are employed by corporates and businesses just to continue to have that competitive advantage in the marketplace. But at the same time, if you look at it from the individual perspective, it's important for that person to make sure that while his knowledge in that industry in general is something that he will continue to employ in the new organization, and that is his right. But at the same time, disclosing something which is specific to the previous employer, anything specific to any particular project, data points, all that is essentially a no-no, and which can any such disclosure can lead to contravention of the obligation that person had in the employment contract or the separate NDA. So these are some of the practical things that play out. Um, some other typical situations could be like, you have like the first one, if you see, there is a one-way NDA, under which, you've disclosed, one of the parties disclosed some information to a third party for executing some project. And then you later figure out that the third party's ex-employee has used some of that information that he had access to. And in that context, there is a bit of a data theft or breach of confidentiality. Now, here you can go after the third party, and then the presumption is that there was an NDA in place. As you said, is the NDA sitting there, and then you are able to make that third party accountable for not having enough checks and balances around that employee. If you file a case, so you would most likely make both that third party and that formal employee of the third party as the defendants, and then you will seek injunction, and you may also seek damages based on how much harm it has caused you. Another scenario could be, for example, you've already filed a provisional application, and now a third party has to get access to the information sitting in that provisional patent, and but he's not willing to sign an NDA. What do you do in such situations? Any thoughts? Will you go ahead, or you will shy away from sharing that information?
There's some comments which have started coming in the chat box, but it
Yeah,
has been very active, Ravi. And everyone is
yeah,
really appreciating the wealth of information you're sharing.
yeah.
But I
So
think I think that one should be very careful while handling with such partners,
yeah,
because once they are showing you unwillingness to sign an NDA, that means they have some, in their subconscious they are not very clear people. So it's better to look for a third party which is willing to do that part with you, and rather than going and taking a risk of damaging your work and your concepts and the other things, handing over to someone like them.
correct. The good perspective, yeah, because it kind of inherently tells you in terms of maybe the mindset, if I can use the word, or
Yes,
the
similar to
cultural
yeah,
approach.
similar to the what body language tells you. Like if you are rubbing your eyes or nose, you're telling a lie. Similar to that, you can draw an analogy to this scenario.
Yeah, yeah. I think people now will be a little more mindful rubbing their eyes. Yeah, but you're right. Now, let's say theoretically, let me play a counter view to say, hey, I've already filed a provisional application. So I'm already protected because I have a date sitting there in the patent office records that on this date I was in possession of that invention. So I'm protected in that sense, right? I mean, so how do we look at that situation?
Well, that's the view that Dr. Shalini is suggesting that yes, why not? The provision application has been filed.
Okay, great. Yeah, so that could be another way to look at it, that in fact, often people rush to file a provisional application so that they are more comfortable making that disclosure to the other parties. And but I agree also with the other comment that it could be a reflection of how the other person is looking at your information. Um, I think generally the responsible parties tend to feel comfortable. Uh, but then you can have some interesting situations around this. So it's all very subjective in terms of how you look at the whole thing. Um, I won't dwell too much into it, but typically, if at all, you are looking at some sort of a, remedial action in case of breach, then, your IT Act can come in handy. Section 43 there talks about breach of sensitive information, and, there are criminal relief available. You can seek damages and things like that. And I won't get into data protection issues in the session today, but anyway, we constantly hear about data breach issues and things like that. and in absence of a proper law, we struggle. Um, Puttaswamy judgment 2017 broadly talked about, that the right to privacy is a fundamental right, which means that you as a employer, uh, while you're sharing information which is confidential with third parties or with your employees, you have an obligation. There's a bit of a two-way traffic now that you also have an obligation to keep your employees' information confidential, which is more on the personal information of the employees. I won't get into too much details around it, but I think it's an evolving, fast evolving field, and you may want to, kind of, keep a track of what's happening in that space. So broadly, this is what I had to share. This slide here essentially is a kind of a summarization of everything that we discussed. So I won't get into the specifics around it. But I think, as I said earlier, it is essentially around building in a culture, in the organization, so that people generally respect the information that they have access to, and also at the same time, make NDAs as a part of life, rather than feeling uncomfortable about, having that legal instrument as a part of your checks and balances. So with this, I'll close my presentation, and thank you so much to all of you for the opportunity. And Hemang, back to you.
Thank you so much, Ravi. I think let me turn the floor over to Anirban, and Ravi, if you can hang around after then, we can probably take some questions as well.
Sure, Hemang. Thank you.
Anirban, over to you.
Yes. Good afternoon. I think it's a tough act to follow after such an engaging presentation of Mr. Bhola. So, Kirti, have you given me the sharing option?
Yes, sir, you can share your screen.
Okay. So, what I'm going to do is I'm going to take just about 5 or 10 minutes. I'm going to show you of the, the L2 Pro presentation. I mean, what the L2 Pro IP e-learning platform is about. And then I will take you through the chapter which specifically talks about the NDA and restrictive covenants, and I will just take 5 minutes there. Most of the information there will be almost a repeat of what Mr. Bhola has done, but then of course you have this material with you and you can refer to it time and time again. So just a minute, I'm going to share my screen in a minute. Can the attendees see the screen?
Yes.
Yes, sir.
So as Hemang had had said in the beginning, L2 Pro India is an IP e-learning program which has been developed by Qualcomm, NLU Delhi, and DPIIT, the Department of Promotion of Internal Trade and Industry. So we had this has been done with the engagement with the government, and here we can see the previous secretary inaugurating the program. So the L2 Pro e-learning program is designed to educate Indian startups, micro, small, and medium enterprises, and innovators on the fundamentals of intellectual property. We have 3 modules, the basic level, the intermediate level, and the advanced level. And each of these covers, different lessons. So the basic level takes you through general introduction of intellectual property and patents, trademarks, geographical indications, copyrights. And at the intermediate level, you learn how to file and acquire IP, then IP searches, assignment and licensing arrangements. And at the advanced levels, you learn a little bit more on intellectual property. So depending on your need, you could kind of, take whichever lesson that you want. And you can take any lesson and on any order, whichever is relevant to you. This is how the App Store looks like. You have very engaging lessons which tells you details about the subject, and you have some quizzes, and then at the end you have an assessment. These are some of the we also have. So at the beginning of each lesson we have an introductory video, and then we have a final video, a summary video, which actually summarizes the lesson. And in the beginning of the webinar, some of you who had joined, you could see the introductory video to NDA and restrictive covenants. So, and then at each of the modules, once you give the exam, you will get a course certificate. So you will get 3 course certificates, one at the basic level, then at the intermediate level, and then at the advanced level. So I'm going to just take you very quickly through the course so that you can have a look at it. So this, when you open the course, when you log in, you will get this navigation page, and then you can go through this. So the 5th lesson is non-disclosure agreements and restrictive covenants in employment agreements. This is how the course starts. This is the video which we have heard before, and then this is the course structure. So like something, I'm going to repeat something what Mr. Bhola has said, that as entrepreneurs you will deal with IP related to inventions, innovations, creations, and building your own business identity. You'll also need to protect any valuable information that your company may have. Therefore, in this module, we will focus on certain agreements that can safeguard your IP assets. Startups, as Mr. Bhola said, startups often find themselves disclosing details of their innovations at external meetings, including investor pitches, conference, and competitions. In these situations, the entrepreneurs are taking a risk that their confidential data would be revealed to outsiders and they would lose their competitive advantage. In such situations, do consider establishing non-disclosure agreements prior to these meetings. So when protecting confidential information through NDA, we learned that NDAs are legally binding agreements between 2 parties with the purpose of classifying confidential information and prohibiting one or both parties from disclosing the information that is shared through the NDA. The parties to a non-disclosure agreement are the party which is sharing the information, which is known as the disclosing party, and the party receiving the confidential information is called the recipient party. Apart from the disclosing and recipient parties, there may be some third parties to an NDA. For example, investors, employees, business partners, or lawyers with whom the recipient may want to share the information. It may be a good practice to include all such parties in the NDA and clearly delineate the roles and capacity of each party involved to avoid the possibility of leak of information in the future and to make your NDA as comprehensive as possible. So here is a quiz, and I would like the attendees to attempt this quiz. When formulating an NDA, one common mistake to avoid would be not including a definition of confidential information, disclosing the confidential information to third parties before signing the NDA, both A and B. It would be great if you can indicate your response in the chat box. So these are the kind of brain teasers which are there in the course, so that always kind of which help you understand the course much better. So Mr. Bhola has of course covered this, but these are the key elements every NDA must contain in order to be valid and enforceable. These are definition of confidential information, purpose of NDA, identification of the parties, term and duration of the agreement, permitted use of the information, non-use and non-disclosure clause, disclosure required by law, jurisdiction and applicable law, remedies in case of breach of agreement, exclusions from the scope of confidentiality, and terminating the NDA. So Hemang, I would like to close here because there are some questions from Mr. Bhola. and we can take those questions, because this course is available to everyone and they can take the course on their leisure. Thank you so much.
Sure. And while Ravi comes up, I wanted to just comment. I've been replying on the chat box. L2 Pro India is completely free. Its thought process was that hey, this is a reference information that we need to have, right? I mean, ideally, uh, you know, most innovation happens, in our daily life. And if you have something which is easy to look up, that was a thought process behind L2 Pro. And the language also is meant for, everyday people like you and me who are not, let's say, lawyers necessarily. We would love to have Ravi's access all the time, but we also know that's not always possible, right? So that's the intent behind L2 Pro India, and it also has resources, right? So there are any areas where there is a lot of helpful information available. You can look at the resources and get access to it all the time. So Ravi, I'm not sure if you've had time to look at the questions, but
I had, yeah,
okay, and you did cover a lot of those. Uh,
yeah.
So, so I think there is one which was sort of like a common trend, which was what are the legal actions which can be taken, in case of violation of any.
Yeah. So, typically what you can do is you can, let's say, approach the court. That is one option, where you seek an injunction or order. Injunction order would essentially mean that you are seeking directions from the court that the person in question or the organization in question should stop any dissemination of information which is confidential, and you can also seek damages. And I think there was some question around, how do you calculate the compensation or damages? So everything essentially depends upon, let's say, the loss that you believe you have incurred by way of that breach of confidentiality. And there are, tools available to help you quantify that. Honestly, you can never really pinpoint very specifically that this is the amount. So a little bit of assumption is built into that calculation. But then there are mathematical models and established ways and means to determine what kind of damage that leakage or breach of confidentiality has caused to your business. So that is there. And I saw there was one question, Himang, I think from Tarun, which talked about if the organization has, somewhere, there's a breach in terms of personal information of employee being shared, or sold, if I can use the word. So Tarun, under the IT Act, there is section 43A, which is under the current law, which may undergo change, once you have a data privacy law in place, new one. But under this one, if your, let's say, sensitive personal information is shared by the, let's say, the employer, and it could be your bank information, your, let's say, your sexual orientation, your religious beliefs, anything which could be construed as a sensitive personal information. Then you can actually seek compensation from the organization. And you also have an option in certain cases. uh, I'll not get into that, but in the cases where, for example, intermediary liability comes in by platforms like, Twitter and, Facebook and those kind of things, where there could be even, provision for imprisonment. So that way, law does have a pretty decent mechanism in place to protect the personal information of the employees and the repercussions in case the employer is not able to fulfill that obligation. Yeah. Yeah.
Hi, Ravi. I have a question.
Yeah.
Say, I don't want to apply for a patent for a innovation or a development of a functionality because I don't want to explain to anyone how we are solving the problem. Then
Yeah.
what are the best practices which I can be doing in my company so that I can protect in the future if someone comes back saying they filed a patent later or something like that?
Yeah. So, I mean, one option which may not fully address the issue, but to some extent partially address it is trade secrets. While we don't really have a trade secret law in India, but essentially it is driven by your contract law where you have systems in place to keep your information confidential. uh, it is a burdensome exercise because tomorrow if somebody within your organization leaks that information, then you may have then it'll be known to public at large. But trade secret is one option in case you don't want to go for patents. But the issue is, it depends for how long you can keep it as a trade secret. Once we have a trade secret law in place, and as Hemang, I'm sure, already knows that there's a lot of conversation around, having a trade secret law. Our joint parliamentary committee last year talked about, having one. So in 2, 3 years, you will hopefully have a trade secret law which will give you a better instrument, legal instrument, to take care of the point that you raised. But the flip side, right now is that if third party independently develops the same invention, hmm, then you can't really do anything about it, and that's where patent comes in handy.
Yeah.
So you have to take a business call, how which instrument you want to use, because patent can means disclosure, but you have a monopoly. Trade secret
Yeah.
means you can actually keep it for more than 20 years if you can, but if you lose it or somebody independently develops it, you have no control over that. Yeah.
Okay. Thank you.
Yeah.
Sir, is there any limitation for this? That
Limitation in terms of.
when do I ask for the claim? If there is a breach of NDA,
Hmm.
is there any limitation to ask for the claim?
So the general law for limitation, talks about 3 years, but then, it could be the often, courts have been generally liberal on that. And often it is 3 years from the time you became aware of that
Exactly.
breach. So, so one, of course, there's a broad, term around this, but then, often we have seen the courts have been generally a bit liberal on that timeline.
So I was reading a case where the father had developed a technology, and after showing his PPT, he was murdered and stolen. That it's technology, and his son came to know when he became an adult.
Hmm.
So
Hmm.
can he file that case?
So I think theoretically he can. One, as I said, is when the knowledge was made available to him. Clearly, yeah, there could be a case. Of course, depends upon the specifics involved. Yeah. Hemant, any further questions? Or
There
Thank
is,
you very much, sir. Very good.
thank you.
thank you, Sanjay. Thank. There is one which is, I guess, relevant to startups and especially as they are raising, uh, you know, funding and all that. Right? They'll be talking to various investors, and investors generally are in the know of, let's say, similar tech or other startups in the place. Is there an approach, or like, do you recommend NDAs with investors? Is there an approach because we've heard that just because investors the way they operate, they may be reluctant to sign one.
Yeah. Yeah, I mean, exactly, as I had earlier also mentioned that it's almost impossible to, have an NDA executed, especially during the very early stage of engagement with investors. More mature institutional investors tend to have a slightly different approach, but yes, otherwise at an early stage, there's a struggle. And our recommendation is at two levels. One, any and every communication with such investors or potential investors should be preferably, even if it's an oral conversation, you have to bring it up that what you're sharing is confidential. Often it's recommended to supplement that with a written communication, broadly articulating that what was discussed broadly in terms of A or B or C subject matter is confidential, is your proprietary information. your standard, the footers in your emails, for example, should have that. Any slide deck you share with investors, you should have it on every slide. Um, that's one part of it. Second, is that how you have treated that information within your own startup. That becomes equally important because I can share anything and everything with the investor, calling it a confidential, but if internally I have not treated it as a confidential information, it is shared liberally, left, right, and center. Then tomorrow, if you have to establish a case of infringement or breach of confidentiality, the counter argument from the investor could be, hey, you've been sharing this information with anyone and everyone, with your third parties, with your subcontractors. You didn't have any contract with them. How come you are bringing in this additional obligation on me? So at two levels, you need to deal with this issue to be able to ensure that your information is treated uh, as confidential by the prospective investors. Yeah.
I think
And
on that note,
also maybe, sorry if I can take just 30
please,
seconds more, is that, if you are working as a startup and working through a platform, and then you have, let's say, panel of angel investors through an accelerator program or through an incubator, then often we suggest the accelerators and incubators that when they bring on these angel investors or early stage investors for such kind of pitches, if that it can be facilitated through those accelerators and and the incubators, so that young companies are protected through that platform. Yeah, but otherwise one-on-one it's very difficult for startups. Yeah.
Mr. Ravi, this is Mohammed Maaz, this side from Aligarh Muslim University. I am the incubation manager here at Department of Business Administration. In fact, I was about to ask you this question, which you have already answered. Basically, what advice to pass on to the people incubatees, basically to safeguard their technical information, which is pertaining to close to patent or about to file or coming to a MVP level. So you have already answered that, but thank you very much for a very informative session, sir. Appreciated.
Thank you so much, man. Thank you.
Thanks.
Mark, over to you. Yeah.
Ravi, this was a very, very insightful session. Like
Sir,
really a wealth of information which has been shared today. And unfortunately, we've gone 12 minutes past our time. So, uh, thank you so much. Both Ravi and Anandvan, great
Thanks.
presentation, and everyone at the audience. Thank you for attending today. If you have any questions, please email the ASSOCHAM team. So we have an ASSOCHAM IT Facilitation Center. We can get back to you through that. And of course, you're all a part of it. We are there for you all, right? So we'll help you. If you have not, please register for L2 Pro India account. You'll see a lot more of such helpful information there. And of course, sincere thanks to the ASSOCHAM team for all the hard work in arranging this. And once again, thank you to our speakers, Ravi and Anupam. Thank you. Have a great day.
Thank you so much. Thank you.
Take care.
Thanks.
Bye-bye.
ಅಂದ್ರೆ ಬೇರೆ ఒక 5 ನಿಮಿಷ ಮುಂದೆ